than 20 minutes on this, and we'll have to wrap up here.
法案
Bill. We now resume the second reading debate on the Child Abduction Legislation Miscellaneous Amendments Bill 2013. Ms. Sit Ho, member of the Mills Committee on the above bill, will address the Council on the committee's report. Ms. Ho. Thank you, Mr. President. On behalf of the Chairman of the Bills Committee on the Child Abduction Legislation Miscellaneous Amendments Bill 2013, Mr. Dennis Kwok, I would like to report on the deliberations of the Bills Committee on the major proposals in the bill. The purpose of the bill is to amend the Child Abduction and Custody Ordinance, CAP 512, CACO, and other enactments to provide for combating child abduction and for better implementing the Convention on the Civil Aspects of International Child Abduction, Hague Convention. The issue of guardianship and custody of children has been discussed for many years and was referred to the Law Reform Commission by the then Attorney General and the Chief Justice in April 1995. The report on international parental child abduction was published by the Law Reform Commission in April 2002, and the legislative amendments in the bill are based on the recommendations made in the report of the LRC. Clause 9 of the bill seeks to add new provisions to CACO to empower the Court of First Instance, CFI, to make provision order, location order, and recovery order in the relevant proceedings to tackle the problem of cross-border child abduction, require the notification of prohibition order or recovery order to the Director of Immigration, and empower immigration officers and police officers to detain a child being removed from Hong Kong in breach of a court order. The Bills Committee notes that there is no provision in the bill empowering CFI to vary, suspend, or discharge the prohibition order, location order, and recovery order so made under CACO, and has examined the need to empower CFI to do so. The Bills Committee also notes that the object of the existing CACO is to give effect to the Hague Convention, and that CFI has the jurisdiction under Section 6 of CACO to hear and determine an application under the Hague Convention. Given that most proceedings concerning custody or access order are dealt with in the family court, members have suggested that the family court should also be empowered to grant a prohibition order under CACO. Having considered members' concerns and consulted the judiciary, the administration has advised that it will add new provisions to the bill to state specifically that the court that made the order may vary, suspend, or discharge a mirror order or a prohibition order made under the relevant sections in CACO. As for the suggestion to empower the family court to grant a prohibition order under CACO, the administration has advised that the judiciary has expressed concern about the extension of the power to the district court to make prohibition under CACO, which would confusion to legally qualified and lay court users. To clearly differentiate provisions relating to Hague Convention cases from those governing cases that do not concern the operation of the Hague Convention, the administration therefore proposes to amend the bill with a view to introducing a three-part structure of CACO. Specifically, the proposed Part 2 of CACO comprises provisions giving effect to the Hague Convention, under which CFI will have exclusive jurisdiction for matters contained therein. The proposed Part 3 of CACO comprises other provisions combating child abduction in Hong Kong. Both CFI and the District Court, including the Family Court, will have jurisdiction for matters contained in Part 3. Members welcome and support the administration's proposed three-part structure of CACO. The Bills Committee has also studied in detail the proposal of empowering immigration officers and police officers to detain a child who is reasonably suspected to be or is being removed from Hong Kong in breach of a court order of which the Director of Immigration has been notified. Members are advised that the policy intent of the proposed power to detain is to prohibit a child irrespective of whether the child is leaving Hong Kong alone or is accompanied by another person, from being wrongfully removed from Hong Kong so that the child can be returned to the appropriate person. The administration has reiterated to the Bills Committee that the power to detain a child will not be exercised unless the relevant conditions prescribed in the bill are satisfied. In addition, the relevant enforcement departments, i.e. the Immigration Department, the Police, and the Social Welfare Department, have coordinated among themselves on the workflow and arrangements of the enforcement of a recovery order or a prohibition order. Details be set out in the administrative guidelines to ensure suitable coordination among the departments concerned. During the course of deliberations, some members have expressed concern about the implementation of court orders issued in Hong Kong in relation to CACL in places such as the mainland and Taiwan, which are not a contracting state to the Hague Convention. The administration has advised that the current mainland law does not expressly provide for the recognition on the mainland of a divorce, maintenance, or custody order granted by the Hong Kong courts, or for its enforcement on the mainland. Nevertheless, there have been precedents whereby the courts in Taiwan recognized and enforced matrimonial judgments made in Hong Kong. The administration has further advised that the Department of Justice will continue to discuss with the mainland authorities the relevant issues concerning an arrangement for reciprocal recognition and enforcement of matrimonial judgments and orders between the two jurisdictions, and report progress to the Panel on Administration of Justice and Legal Services as appropriate. Some members have noted with concern that parental-child abduction is not a criminal offence and have asked the administration to reconsider whether to criminalize such act. According to the administration, the proposed power to detain a child when he or she is about to be removed out of Hong Kong in breach of a prohibition order is an improvement to the existing regime as well as a proportionate step to preventing the unlawful removal of a child by his or her parent. The new power can also prevent parents from making further attempts to leave Hong Kong with a child by other means or to hide with a child. Similar to other court orders, breach of a prohibition order may constitute contempt of court, sanction of which ranges from a fine to a term of imprisonment. While the administration does not consider it necessary to criminalize the act of parental-child abduction at this stage, it will keep track of the experience of implementing the bill and reviewing the issue of criminalization of parental-child abduction in the context of the changing circumstances. Members generally consider the administration's explanation acceptable. Mr. President, in the light of members' views and suggestions, the administration will move a number of committee stage amendments to the bill. The administration will also introduce other minor and technical amendments which have the support of the Bills Committee. Mr. President, I would now like to speak in my individual's capacity on the amendment bill. In the chairman's report, it talks about the operational problems with regard to prohibition order. We have received many cases in domestic violence cases when one side, normally the woman, applies for a divorce, and she would go to seek legal assistance, and from the date when she gets the legal assistance, when she actually applies for a divorce in the family court, and to when the court issues a prohibition order, that takes a very long time. Well, based on past cases, it shows that one party, without the consent of the other party, takes the child out of Hong Kong to the mainland. And on the mainland, there is no provision in the mainland law recognizing the matrimonial orders issued in Hong Kong. So especially for a child which is very young, and when he or she is taken to the mainland, he or she can never be found again. So we are very worried that during the whole proceedings, a woman from mainland may come to Hong Kong. She doesn't know about legal proceedings in Hong Kong, and she tries to seek legal aid to get a divorce. And then during that time, her spouse knows about what she's doing, and then there is a long period in which the spouse can easily take away the child. But the administration told us that, well, if you go to seek legal aid, then that can be done urgently, say within 1 day's time. Well, even with the help of a social worker, you can seek legal aid, and then you try to file a divorce, and then also you want to get a prohibition order, then that the time gap can be very long. And the law also imposes the responsibility on the person who files a divorce to notify the immigration department. Well, as I said, the spouse may be have low education attainment, and she may be accompanied by social workers in all the proceedings, and well, the law sounds very good. Well, she has this right to notify the immigration department and so on and so forth. But in the cases that we've dealt with before, we've seen a woman who doesn't know her legal responsibilities or rights. So during the scrutiny of the bill, we asked the administration to do some coordination work. Now, if the woman is accompanied by the social worker, then if she seeks legal aid, then can she immediately give the name of the child to the immigration department so that the department can have the name of the child as soon as it's possible, and she doesn't have to wait till the entire proceedings process have ended and after the prohibition order has been issued. We've received many cases like those, which take a long time for prohibition orders to be issued. Now, the amendment seeks to expand the authorities to issue the prohibition orders from just the CFI to the district court or the family court as well. So it means that the woman doesn't have to go to 2 separate courts. All she has to do is she can get a prohibition order in one court. I think that's a step forward, but then we don't think it's enough. I think the different government departments must coordinate among themselves. Once the divorce application is received, then the name of the child will automatically be passed on to the immigration department. Also, as we said, Taiwan and mainland are not contracting parties to the Hague Convention. And for the mainland, there is no provision in its law to recognize the court orders issued in Hong Kong, and we now have to rely on government officers to talk with the mainland on individual cases. As we stated in our report, during the scrutiny of the bill, the government departments have said that they would try to discuss with the mainland authorities as soon as possible, so that there will be sort of a linkage between the two places, and that there is a legal framework in place to enforce the court orders issued in Hong Kong. Mr. President, we are seeing so many cross-border marriages these days, and the divorce rate is also not on the low side. So this is something that we should have already paid attention to a long time ago. Well, in 1999, we discussed this issue, and we sought NPC's interpretation of the right of abode issue, and then that was dealt with quickly. But then for very concrete or specific livelihood issues like these, we're not acting fast. I mean, it has to do with the welfare of the divorced parent and the child, and you've been procrastinating. Now, Mr. Matthew Zhang, you said that you would like to take a pragmatic approach, but then how come that in these livelihood issue, you took 17 years after the handover to work on it? It's not the protection is not yet here yet. Well, not to mention non-contracting parties. Well, even for Macau, which is a contracting party, we're still neither here nor there. And the Macau joined the convention in June 1999. Is now 15 years on. Now, at that time, the Secretary for Welfare and Health gave us a paper, and when I looked into the relevant paper, there was this undertaking stated, and that is in June 1999, Macau joined the Hague Convention, and the government undertook to make arrangements with the Macau authorities in relation to prohibition orders and matrimonial orders and so on. Now, this year is 2014, and when we scrutinized the bill, we asked, what about Macau? Well, it seemed that nothing had been done so far. So today, the government is undertaking that it will discuss with the mainland and Taiwan authorities on how to establish linkages. Well, I don't trust you, because if you look at what you did with Macau, for Macau, it was already a contracting party. You took 15 years before you got anything done, not to mention places which are not contracting parties. The third point that I would like to raise, Mr. President, is about the welfare of the child. In our report, the government, after much consideration, that said that it would not be criminalizing a parent who is in breach of the prohibition order, and the reason being that if the child's wish goes against the court's order, then it will be very complicated to get statements from the child and so on and so forth. Well, this is in fact the case for the family court in dealing with divorce cases and in issuing guardianship and custody order. Now, if the child's views have not been carefully heard, and then ultimately, if the child's wish goes against the court order, then if you are holding the parent criminally liable, who is taking the child out of Hong Kong, and then there will be a criminal record on him or her, well, then if that is the case, then it will be like rubbing salt over wounds. In matrimonial disputes, parents should be able to deal with their own emotional problems, but then the child is always innocent. The child has certain feelings and emotions towards the parents, and if the child knows that if the parents are fighting for his or her custody, and then one of them is being prosecuted or taken to jail, then that would deal a blow to the child. So we agree to the administration not making parental-child abduction a criminal offense. But at the same time, we hope that the administration should follow up carefully on whether the courts in the proceedings give adequate opportunities for the child to express his or her wishes. Well, a child may be very young, and under this law, anyone who is below 18 is considered a child. Now, if a child is 15 or 16 years old, of course, he or she can express his or her own wish. But then for a child who is just, say, 5 to 6 years old, he or she may not be able to make an objective assessment of the case, and, well, the child may just be speaking about his or her feelings towards the parents. Well, perhaps a parent is a drug abuser, but then the parent loves and cares for the child very much, and the child would like to be with him or her. So that may be not work for the best interest of the child. So in the court, there should be adequate support facilities like psychologists and social workers who are there to help, who are there to listen to the views of the child before the decision on the child can be made. The last point that I would like to make is about separation of or collaboration of powers. Well, in the white paper issued by the State Council recently, we are against that because it says that the judiciary is part of the administration. But there is another way of collaboration of the three powers, and I think this is a desired model, and we can take reference from that. And I think a very good example is this amendment bill. In the amendment bill originally put forward by the administration or the executive, and it in relation to prohibition order and recovery order, the power to issue such orders rests only with the CFI. But of course, the legislature knows public opinions more than the executive or the judiciary, and we raised that a lot of grassroots families and women, and if they have to go to the family court to take out certain procedures, then it's already a burden. If they have to go again to the CFI, then that will be very taxing on them. The procedures will also be cumbersome, and then that leaves room for the other side to bridge the possible order to be issued and then take away the child out of Hong Kong. So during the scrutiny of the bill, we raised this point. We think the administration or the executive for bringing back our opinions to the judiciary for a discussion. Now, the judiciary may not agree with everything we said, but at least they agreed to our suggestion on the prohibition order. So what we are seeing today is that the bill will be divided into three parts. The prohibition order and recovery orders and so on and so forth are categorized or are sort of put into the three parts. And then there is a division between cases related to Hague Convention and those that are not related. So in terms of the recovery order or prohibition order, that also can be issued now by the family court or district court. Now, from this case, you can see that the three sides, the three powers have been discussing the fine points, and we still maintain the independence of the judiciary, and we ask it to consider public opinions, and it agreed. So what we end up is that the best interest, well, the interest of the members of the public is protected. And this kind of collaboration among the three powers is the best model. But what we are saying is that what we meant by collaboration of three powers, we are not trying to influence the independence of the judges in ruling on cases. So this is a point that I would like to make. Now, before the enactment of the bill, there is this collaboration among the three powers. We try to ask the judiciary to understand what the public thinks, and at the same time, we respect the independent way of working of the judiciary. And so we came up with this final version of the amendment bill. I think this is a route that we should be taken in terms of collaboration with three powers.
Mr. Tam Yu Chung, Mr. Deputy, the gist of the Child Abduction Legislation Miscellaneous Amendments Bill 2013 is to increase the court's power in combating child abduction, to limit the wrongful removal of child without the consent of the father or the mother, and this will help us protect the welfare of the child. So the DAB supports the bill. In Hong Kong, we have a rising divorce trend. In 2012, we stood 9th in world record, and every year we have over 20,000 such cases, and we will also have to take care of custody rights and also the access rights, etc., and these disputes between parents. Some parents do love their children a lot, but others feel hurt. So before getting the consent of the other party, they might want to remove the child out of Hong Kong. And present, the Child Abduction and Custody Ordinance does regulate such behavior. However, it is not effective in preventing such from happening. Therefore, the interests of the child can be eroded. In the bill, we have the three orders and one added power in that the court can issue a prohibition order, a location order, or a recovery order. And the Immigration Department can detain a child who is reasonably suspected to be or is being removed from Hong Kong in breach of a court order. Now we have a complete protection regime so that the mother or the child, the father cannot remove the child out of Hong Kong wrongfully or illegally. We think this arrangement is reasonable. We cannot do without either of the orders or the power, especially the power to detain by the immigration officer, because custody means the biggest interest to the child. If someone breaches the court order and tries to take the child out of Hong Kong, then that would amount to eroding the right of the other party to have the child's custody. So the Immigration Department must be empowered to be able to detain a child in a place of safety and to return the child to a proper custodian. This is a bill that is seeing the biggest structural change at the committee stage in recent years. In studying the bill, we found that in terms of a marriage dispute or marriage case, very often there will be the application for access right and custody rights. Very often these are judged at the family court. The bill introduces the prohibition order. Now, in its nature, it is stemming from the custody right and access right, but then this is only within the jurisdiction of the CFI. Therefore, we need to judge the same case at two levels of court. This will lead to a waste of judicial resources, and also we will not be able to protect the interests of the child in a timely manner. The bill's committee therefore proposed that we should empower the family court to also issue a prohibition order. However, in the present CACO, since it is an ordinance to implement the Hague Convention, this is something that is to the exclusive jurisdiction of the CFI. Therefore, in order to also take care of the need to give family court a timely approach, the administration has done an overhaul to the structure of the bill. It will move a CSA to effect the structural change. The provisions and sections will be rearranged, and the effect of that CSA will be very positive. It shows that only when the executive and the legislature can have sincere and honest communication and cooperate with each other, then can we facilitate the implementation of measures that will benefit the public. This should be enlightening to the present political gridlock that we are facing. In the course of studying the bill, we studied most whether we should criminalize abducting parents' behavior. On this point, the DAB supports the Law Reform Commission's view. The two adults may have a marriage dispute, and then without the consent of the other party, one party may wrongfully remove the child out of Hong Kong. Well, this is something within the family court's jurisdiction, and the prosecution can only worsen the confrontation between their parents, and that may affect the relationship between the parents and the child, and that is not in line with the interests of the child. And very often, the child would voluntarily follow the parent that takes him or her out of Hong Kong, and there will be immense prosecution difficulties. Now, in the course of abduction, if there is kidnapping or false imprisonment, then we can act according to the criminal code or the common law in order to have criminal sanction imposed upon the wrongdoer. Therefore, we can start with the present criminal arrangement for dealing with kidnapping. We think that is more effective. As the mainland and Hong Kong are more integrated, there are more cross-border families. However, since the mainland is not a party to the Hague Convention, and there is no way to recognize and enforce the divorce orders and custody orders made by Hong Kong courts. So if children are taken to the mainland, the recovery order and location orders issued will not be enforceable on the mainland. And the police can say they have a reason to believe that the child's personal safety is threatened, then they can, only in that circumstance that they can liaise with mainland authorities for help. This is not an ideal situation. We hope Hong Kong can talk to the corresponding mainland departments in order to arrive at a mutual legal assistance arrangement for marriage disputes, so that the measures proposed by this bill will be able to be effective in protecting the interests of children in cross-border families. I so speak, and we support the resumption of second reading debate and all the CSAs of this bill. Thank you.
Mr. Raymond Wong. Thank you, Chairman. The Child Abduction Legislation Miscellaneous Amendment Bill 2013 is to amend the CACL and other enactments to combat child abduction and to more effectively give effect to the implementation of the Hague Convention in Hong Kong. And I am a member of the Bills Committee. We're not talking about normal or ordinary child abduction, but rather cross-border parental child abduction. Since the 70s and 80s and the last century, many Hong Kong people got married to mainlanders. There are differences between, cultural differences between the two places, and many of the marriages failed. The couple may have a child, and then there is a problem of parental child abduction. To the Chinese, well, they don't find this a problem because, after all, this is their child. And in 1995, the Secretary for Justice and also the Attorney General and Chief Justice identified such problems and asked the LRC to study into the problem. The LRC released in April 2002 the report on intentional parental child abduction, and there are 6 major recommendations to further protect the child. In the community, there have been suggestions that there should be criminalization of parental child abduction. During the committee stage, we have discussed about asking the administration to see if it should make the parental child abduction a criminal offense. And the administration cited the LRC saying that there is the problem of parental child abduction is serious. Hence, there is no need to criminalize such acts. The LRC has also considered about the criminal and civil liabilities of parental child abduction, including the offense against the personal ordinance and also protection of children and juveniles ordinance. And they said that according to common law, that if the mother or father can be convicted for false imprisonment. But then these provisions are quite vague in that regard. They don't clearly state that if a parent adopting the child is breaching such laws, and the LRC believes that parental child abduction should not be so criminalized along the lines of the UK Child Abduction Act 1984, and proposed other recommendations to foil the attempt to remove the child from Hong Kong. Also, the LRC goes against the views of the House of Lords, and in Chapter 2 of the LRC's report, it is said that the should be dealt with as a contempt of court, or if it is, except in the most blatant cases. What do we mean by most blatant cases? And that is if the parents totally disregard the relevant provisions. And according to the common law, the parents can be convicted for false imprisonment of the child. But then I don't think the administration's point stands. The making it an offense will make things even clearer, and it will not catch people inadvertently. But then since the administration went against criminalization, so we're just trying to raise our suggestions here. Well, even if the bill is enacted, I hope that the administration can further study on whether to criminalize parental child abduction in the future. The government says that it agrees with the LRC's recommendations and amends the CACO, and it was only in July 2013 that the bills was submitted for consideration. Starting from identifying the need to amend the law up to now, when the bill is being put forward for second reading, that's 19 years already. That's so very ridiculous. 19 years we identified the problem, but then it's only after 19 years that we are resuming the second reading debate of this bill to come back or resolve the problem. This is so very ludicrous. From 2002 to 2013, 13 years, I don't know what the Secretary for Justice has done. Now, if a child was born in 1995 and he was abducted and he's now a grown-up and he was not covered or protected, from 2002 to 2013, what has the Secretary of Justice done in these 13 years? Well, our administration has always acted like this. Even for non-controversial issues, the administration is already procrastinating. Now, for the issues which are controversial, how much more procrastination there will be? Well, sometimes it can be very strange. Well, for the for the more controversial issues, the government is acting in the other way, trying to ram things down our throat. The bills has new provisions to empower CFI to issue prohibition order, location order, recovery order, and also prohibiting people taking the child out of Hong Kong to other places. The bill also empowers the immigration officers and police officers, if they reasonably suspect that a child is being taken out of Hong Kong against a court order, or they are being taken out, or can detain them in a place of safety. As I said, well, these are not controversial recommendations. They warrant our support, but on the technical side, I think there are some problems. In Section 15, there is a prohibition order. Now, the CACO has all along been prohibiting the parent, without the consent of the parent who has custody control of the child's residence or with whom the child has regular contact, take the child out of Hong Kong. Now, the proposed new Section 18 further empowers the CFI to issue a mirror order to prohibit taking a child out of Hong Kong to a place outside the child's habitual residence, or a place specified or jurisdiction specified by the Hague Convention order. Matrimonial cases often involve legal aid, but then the application for legal aid can be cumbersome, and it takes a long time very often. And one side of the divorce petition may miss the good timing to apply for a prohibition order, then what will happen? Well, this can happen, I think. And the administration said that the legal aid department, upon receipt of the application, as long as the information is ready, the legal aid department can make timely decisions or immediate decisions, and there will not be any delays. But then it may take several weeks to provide the relevant information. For example, we have to give information on the bank accounts, asking the bank to make copies. Well, that can not be done very fast. Now, if the parent doesn't have online banking account, then, well, he or she cannot download the bank statement. So this can't be done instantly. So I think the administration response is totally out of reality, because the parent then will not be able to get legal aid assistance. They may not do it in a short time. So without the prohibition order, the child then can be taken away by the other side. Now, as for the location order, the paragraph 21 of the report said that in the party can use the location order to get information in seeking custody or guardianship order, and the information may be used not to the advantage of the child and the interest of the child. And there may be another purpose for using the information. The administration has taken note of the information, the interest of the members. So in section 16, the administration said, well, please don't ask the colleague not to talk on the phone. Mr. Stephen Ho, please don't talk on the phone during meeting time. Mr. Raymond Wong, we welcome the government has taken heed of our concerns, and that is there should be a limit or restriction placed in the use of the information provided to the court. And the administration has also proposed in section 16 that the court can impose restrictions on the use of information in the location order, and that is that it can only be used for proceeding with cases, Hague Convention cases. And I think that in the provision that should be express provision stating that the information should not be used to the detriment of the child. Third, recovery order. The report says that the new section 20 says that if a recovery order has been issued and it has been notified to the Director of Immigration, the immigration officer can be empowered to detain the child again, and the child will be returned to the specified person in the recovery order. I agree with Section 20 because then it will help effectively combat abduction acts. And I also welcome the administration's inclusion of in the definition of place of safety, the places listed in Schedule 1 of the Protection of Children and Juveniles Place of Refuge Order, then that can help minimize the harm to the child. I think the child abduction has serious consequences to the family. The child may be taken away from the home, from his or her home, and he or she will be far away from their home, and then they will be dealt a blow. And if the child is abducted, it will also create a lot of disturbances to the family members. So we agree that the proposals can help combat parental child abduction problem. And if we implement the proposals, the cases, I mean, there will not be any such cases. Now, if we criminalize parental child abduction, then I think it would serve a greater deterrent effect. So I hope the administration can reconsider criminalizing parental child abduction. Perhaps after the law has been enforced for some time, can you revisit such recommendations, Mr. President? So I speak and I support the second debate resumption of second debate of the bill.
Mr. Ho, Mr. Deputy I speak in support of the bill. That is the Child Abduction Legislation Miscellaneous Amendments Bill 2013, tabled by the administration. I can say that this bill has been tabled quite late because back in 1995, the issue, or a series of issues, were referred to the Law Reform Commission, LRC, by the then Attorney General concerning child custody and guardianship. And not until years later were a series of reports published by the LRC on child abduction, child custody and guardianship, etc. And then years went by, and I understand that a number of pieces of legislations have come into effect on various matters relating to the welfare of children, save and except one issue, that is in relation to custody and guardianship of children. And I recall that in 1996 or in 1997, the former Legislative Council member, Ms. Miriam Lau, chaired a committee on one of the LRC reports. And back then, there were recommendations put forward to amend the legislation. And then, after repeated discussions and disputes, despite the fact that in other jurisdictions further legislative amendments had been put forward after further deliberations, we made no progress at all. Comparing to other jurisdictions adopting the same legal concept with the same legal system in place, we are not making any progress. Joint custody and other concepts have been adopted by other jurisdictions. As for other newer concepts, we have yet to enact legislation to implement them. I hope that Secretary would implement the LRC's reports as soon as possible, at least to make a decision on the LRC's recommendations as soon as possible and to table the relevant bills to intellectual. As for the implementation of the relevant provisions under the Hague Convention in Hong Kong, well, there aren't many controversies. Many of the recommendations we propose have been incorporated by the administration in its CSAs, and we appreciate the administration's effort in incorporating our views, in particular on the exercising of powers by courts. They have discussed with the judiciary, and maybe I'll come to that in a moment. I don't believe we have much to argue about for the resumption of second reading or even the third reading of the bill. I just want to discuss a number of issues and have them put on record. First, in relation to criminalizing the act of abduction, I note that the LRC report also mentions this point, and in some other jurisdictions like the UK, such act is criminal. However, the LRC has not proposed to criminalize such acts, and the administration, following the LRC's recommendation, has not proposed to criminalize child abduction. And we then had a discussion. We also met with deputations it seems that in the community there weren't strong views on this issue of criminalizing parental child abduction. My stance is this. I am not suggesting that parents or offending parents should be penalized criminally. We should not consider the issue from a perspective of penalizing parents. However, for the child's, as far as the children's welfare is concerned, we should consider whether we can deter parental child abduction by criminalizing such behavior. This is important because if such act is criminalized, we can then empower the police to adopt administrative measures by stopping the wrongful and illegal removal of a child out of Hong Kong. This is the quickest way in protecting the children's welfare, and yet I think we all agree that for the sake of the family, we should not criminalize such acts. So I think we all agree on this point. However, the majority view arising from the discussion was that there was no need to criminalize parental child abduction, and a prohibition order would achieve the same effect. And the administration has also explained that the legal aid department would have an expeditious process for the purpose, and the immigration department also guarantees that the prohibition order would be sufficient in stopping the wrongful removal of a child out of Hong Kong effectively. However, time is needed for a prohibition order to be granted, and if the act is criminalized, then once the parent if the parent is considered to have the intention of removing the child out of Hong Kong, then the other parent can swiftly request the police or the authorities to take action. At that time, well, the administration solicitors explained that there are already provisions under the common law to deal with the kidnapping of the parent's own child. However, I asked then why we couldn't have some more expeditious means to deal with the issue, to protect the child's welfare. And yet at that time, most members agreed that we should take this step at this stage, that is by implementing the prohibition order under the civil law to prevent such removal first. And I still have some doubts, but I think that there should be a review in future. I emphasize that it should be done for the child's welfare, not for the sake of penalizing parents. And another point is about dealing with family disputes. Timely intervention by the Social Welfare Department is very important. I remember that some 10 years ago, there was a sad incident. A friend of mine got married overseas, and they also settled abroad. And then they had the matrimonial proceeding, and my friend lost the custodial right of the child. And then my friend illegally brought the child to Hong Kong. And there was an order granted by the court of the other jurisdiction under the Hague Convention requesting for the child to be recovered. And there was also an order issued by the local court ordering recovery of the child. And sadly, my friend was in fact a doctor. And because of his or her love for the child and the resentment, the following morning, the child, along with the doctor, died because the doctor administered an injection for him or herself and the child. And because of the emotional disturbance, the doctor made a very cruel decision to end his or her own life together with the child. So had there been timely intervention by the social welfare department, including social worker, child psychologists, and psychiatrists, it was very important to have timely intervention. What is meant by bringing the child to a safe place? Of course, the child may be brought to a safe place. He may not be endangered personally, but the physical and mental health of the child is equally important. And I emphasize once again that there should be sufficient social workers to deal with such situations. And of course, I hope that there won't be many such cases. But I emphasize once again that the law should not be implemented or enforced rigidly. There should be software to work in parallel with the law. And about family disputes, I think one of our major challenges is cross-border conflicts and cross-border law enforcement. Now, on criminal matters, for example, on expedition of offenders, there are less controversies. However, on family proceedings and family or matrimonial and family proceedings, especially after orders have been granted by the court, mutual help should be stepped up. For example, if a child is brought out of Hong Kong against a court order, there should be respect for the court order, and the two jurisdictions can work mutually to return the child to the original jurisdiction. And this is what we should work on. And it's not difficult to do it. The two jurisdictions have been working on or cooperating on various fronts. As far as criminal and civil matters are concerned, I think this should also be done more expeditiously. On cooperating under the Hague Convention, we have done quite a good job. However, much more has to be done for other states like Taiwan and Macau, and there are also cross-border marriages and family disputes arising from these marriages, and there are also issues that that should be dealt with arising from matrimonial proceedings of such, and Secretary should also pay more attention to these issues. In the long term, with the passing of this bill, the provisions under the Hague Convention can be more effective. And the family court, it is proposed that the family court can also order a prohibition order. This is important because very often the district court or the family court is responsible for dealing with matrimonial proceedings and family proceedings, and family court judges are very familiar with this aspect, and they can make such decision to grant prohibition orders more expeditiously, whereas it will take more time for persons to be sworn in the court of first instance for such orders. So I agree very much that the bill should be divided into 3 parts, and for powers not relating to the operation of the Hague Convention, power should be given to the family court. Does any other member wish to speak? If not, then I'll call upon the Secretary for Labour and Welfare to reply. The debate will come to a close after the Secretary has replied. Secretary for Labour and Welfare.
Mr. Deputy, first of all, I'd like to thank Ms. Sit-Ho for her comments on the report of the Bills Committee on Child Abduction Legislation Miscellaneous Amendments Bill 2013. I also like to thank Mr. Dennis Kwok, Chairman of the Bills Committee, and its members for their valuable comments in scrutinizing the bill over the past month to further improve the bill. And I also thank Mr. Tammy Ruchong for his recognition of our effort. In the course of the scrutiny of the bill, the Labour and Welfare Bureau worked very hard with the members of the Bills Committee, and I really appreciate tolerance from members. In July 2013, the administration tabled the bill, which seeks to implement the recommendations for reform in the Law Reforms Commission's report on international parental-child abduction. The report to enhance the legal protection for children in Hong Kong against abduction. At present, the Convention on Civil Aspects of International Child Abduction signed at The Hague, that is the Hague Convention, is an effective international mechanism for the safe and swift return of a child wrongfully removed from one contracting state to another. Hong Kong, being a party to the Hague Convention, implements the Convention through the Child Abduction and Custody Ordinance, CAP 512, or CACO. The administration agrees in principle with the recommendations in the LRC's report. To implement these recommendations, the administration has proposed to amend the CACO and the relevant rules and regulations to improve the clarity of the existing provisions, and also to give the Secretary for Justice, as the Secretary authority under the Hague Convention, and the court, the necessary powers to deal with abduction cases more effectively. The bill proposes to add new provisions to better deal with Hague Convention cases. At the same time, the bill includes new and general provisions to prevent parental-child abduction cases that do not concern the operation of the Hague Convention. The bill consists of 3 parts. First, the bill will come into operation on a day appointed by me in the capacity of Secretary for Labour and Welfare by notice published in the Gazette. Second, amendments to the CACO. The gazetted version of the bill proposes to amend the CACO, including 1. Amending the long title to state clearly the purpose of CACO is to combat child abduction, so as to cover cases other than those falling within the Hague Convention and to provide for related matters. 2. Amending Section 7 of CACO to expressly empower the CFI to require the personal attendance of any person, including parents of the child concerned, at a hearing of an application. 3. Amending Section 8 to empower the Secretary for Justice to request written reports on matters relating to children with reference to the Secretary's functions as the Hong Kong Central Authority under Articles 7 and 21 of the Hague Convention. The gazetted version of the bill also proposes to add new sections 15 to 21 to CACO to empower the CFI to make a prohibition order against removing a child out of Hong Kong without consent, a location order requiring information about a child's whereabouts, a recovery order for the return of a child, or to require an applicant who has notified the Director of Immigration of a stop order or a pending application of a prohibition order to inform other parties with a custody of or access rights in hand, or each party to pending proceedings concerning those rights, of the fact of notification as far as possible. and to empower immigration department officers and police officers to detain and return a child being removed or about to be removed from Hong Kong against a court order on reasonable suspicion to an appropriate person. Lastly, amendments to the rules of the High Court, the Matrimonial Causes Ordinance MCO, and the Judicial Proceedings Regulation of Reports Ordinance. The bill also proposes to amend Order 121 of the Rules of the High Court, Cap 4, Subsidiary Legislation A, to align with the proposed new provisions. New rules are also proposed to prohibit the publication of information about and the searching and inspection of court files of hate convention proceedings. The administration also accepts the recommendations from the LRC's reports to add Section 48D to the Matrimonial Causes Ordinance Cap 179 to provide that a party to proceedings under the ordinance may apply for a court order prohibiting the removal of a child of the family out of Hong Kong. The new section replaces Rule 94, Sub-Rule 2 of Matrimonial Causes Rules, Cap 179, Subsidiary Legislation A. The bill proposes to amend Section 5 of the Judicial Proceedings Regulation of Reports Ordinance Cap 287 to ensure confidentiality of legal proceedings under CACO. Mr. Deputy, the Bills Committee also looked into possible amendments to the gazetted versions of the bill. Having taken on board views of the Bills Committee, I will move the relevant committee stage amendments later, and I will also explain the details of the amendments. I'd also like to respond to the points raised by the members who have spoken. I think I should elaborate on these points. First, on criminalizing parental-child abduction, a number of members raised concern. I'd like to emphasize that it is the LRC's views that parental-child abduction should not be criminalized, as is in the case in the UK Act, because if it is the father or the mother who abducts the child, it is a very grave act to criminalize such abduction. Some also opines that the power to detain a child being removed out of Hong Kong in breach of a court order is already a step forward in improving the mechanism, and we also find it effective in preventing such wrongful removal of a child out of Hong Kong. It can also deter a parent to remove the child out of Hong Kong or hide the child through other means. And the prohibition order, the breach of a prohibition order may constitute a contempt of court, the penalty of which may be a fine or otherwise. Therefore, at this stage, we don't consider it necessary to criminalize parental-child abduction. However, we'll also consider the situation of implementation of this new provisions to consider whether to criminalize parental-child abduction. Some members also talked about the implementation of such provisions in other non-contracting states such as Taiwan, mainland, and Macau. At present, it is true that there are no express provisions of such, and there are no stipulations in the mainland on the enforcement of the Hong Kong order. However, in Taiwan, any matrimonial judgments are recognized and enforced in Taiwan. We have also advised the Department of Justice to continue to discuss with mainland authorities the relevant issues concerning the arrangement for reciprocal recognition and enforcement of matrimonial judgments, and we will report progress to members as appropriate. As to whether or as to how the matter of a child being abducted into a non-contracting party should be dealt with, such as mainland or Taiwan. The police will assess if the safety of the child is endangered or if the child is considered a missing person. If so, the police will contact the relevant authorities to request them to locate the child and protect the child. This is the first point for mainland and Taiwan. And as for Macau, because we're all both special administrative regions, and Macau is therefore and also a contracting party, since we are two different jurisdictions, Hague Convention doesn't apply to the dealings between two cities or two regions. However, we're also working on mutual arrangements for handling parental-child abduction cases involving Hong Kong and Macau. Thirdly, on legal aid, whether the application for legal aid process would cause a delay of the prohibition order coming into effect and hence the welfare of the child being affected. I want to emphasize that as long as the financial or the means test are met and other circumstances also met, the legal aid department would grant legal aid immediately, and the applicant would get the legal aid required on the same day. And the legal aid department is also empowered to grant certificates on an urgent basis. And to uphold justice, the department may issue urgent or issue certificates on an urgent basis. As for detention of a child, that is, if the police cannot contact any appropriate person or an appropriate parent in time, the social welfare department will definitely look after the child, including drinking water and arrangement for food, until the child is appropriately returned to the parent, to ensure that the child's welfare is well looked after. Finally, Mr. Albert Ho also asked for an expeditious arrangement for considering the report on custody and guardianship of children. In fact, in 2010, we launched a consultation where we also drew reference from other jurisdictions. We're discussing with the Department of Justice on the drafting of legislation. Definitely, we will maintain a close liaison with stakeholders like the Family Council, the two legal professional bodies, and other stakeholders. We hope that by next year we can complete the legal drafting work. I urge members to support passing the second reading of the bill, and also at the CSA stage support the administration's amendments. If the bill and the amendments are passed, at the next stage we will discuss with the judiciary on the details of the rules to be enacted in order to implement the prohibition order, location order, and recovery order. We expect that the new legislation to come into effect in the second half of next year. Mr. Deputy, I appeal members to support the resumption of second reading of the bill.
I now put the question to you, and that is that the Child Abduction Legislation Miscellaneous Amendments Bill 2013 be read the second time. Will those in favor please raise their hands? Mr. Raymond Chan, he claims that he would like to have a quorum call, and the bell will ring for 15 minutes.
現在開始表決。
We'll now begin voting.
Please
check your vote. If there is no problem, please display the results of the votes. 35 present, 34 for, 0 against, abstention 0. I think the question is agreed by a majority of the members present. I declare the motion passed. Child Abduction Legislation Miscellaneous Amendment Bill 2013. Committee stage. Council is now in committee. Members may